ಸರ್ ನಮ್ಮ ವಕಾಲ್ ವೃತ್ತಿಯಲ್ಲಿ ಅಡ್ವೊಕೇಟ್ ಪ್ರೊಫೆಷನ್ನಲ್ಲಿ ಸಕ್ಸಸ್ ಆಗಬೇಕಾದ್ರೆ ಏನು ಮಾಡಬೇಕು ಸರ್?
First and foremost, there must be complete dedication. Dedication ಅಂದರೆ ಏನು ನನ್ನ ಪ್ರಕಾರ? It is not only applying yourself full time to the profession, it is also loving your profession. You should love the work that you do. The moment there is hard work plus that love for the work that you are doing, according to me, that is dedication. ಮಾಡಬೇಕಲ್ಲಪ್ಪ ಅಂತ ಮಾಡಿದ್ರೆ ನೀವು ಯಾವ ಖಂಡಿತವಾಗ್ಲೂ ನೀವು ಉದ್ಧಾರ ಆಗಲ್ಲ ಪ್ರೊಫೆಷನಲ್ಲಿ.
ಇದು ಅಂತಲ್ಲ, ಯಾವುದೇ
ಈ ಪ್ರೊಫೆಷನ್ ಈಸ್ ಮೋರ್ ಬಿಕಾಸ್ ಲೀಗಲ್ ಪ್ರೊಫೆಷನ್ ಈಸ್ ಎ ಜೆಲಸ್ ಮಿಸ್ಟ್ರೆಸ್ ಅಂತ ನಮ್ಮ ಪ್ರೊಫೆಷನ್ಗೆ ಹೇಳಿದ್ದು, ಬೇರೆ ಯಾವ ಪ್ರೊಫೆಷನ್ಗೂ ಹೇಳಿಲ್ಲ ಅದನ್ನು. ಲಾ ಈಸ್ ಎ ಜೆಲಸ್ ಮಿಸ್ಟ್ರೆಸ್ ಅಂದರು. That is because this profession is so taxing. You have to use all your talent in order to be successful. In addition to it, most importantly, you have to do it with ethical values. So you see, look at the combination. You have to be learned, you have to hardworking, you have to love what you are doing, you have to be ethical in what you are doing. This is not an easy task. That is why if you have to be a successful lawyer, you have to adopt all these qualities all in one individual. It is not a question of somebody giving hard work, somebody giving love for the profession, somebody giving you something else. It all must come from within. Without that, according to me, there is no chance. Leave aside luck. That is a different aspect altogether.
ಯಾಕೆ ಹೇಳಿದೆ ಅಂದರೆ, ಈಗ ಎಷ್ಟೋ ಜನರಿಗೆ ಪ್ರೊಫೆಷನ್ ಬಂದವರಿಗೆಲ್ಲರಿಗೂ ನಾವು KG ರಾಘವನ್ ಅವ್ರ ಥರ ಆಗಬೇಕು, ನಾರಿಮನ್ ಅವ್ರ ಥರ ಆಗಬೇಕು, ಹಾಗೆಲ್ಲ ಇರುತ್ತೆ. ಬಟ್ ಸಾವಿರಾರು ಜನ ಇದ್ದಾರೆ, ಬಟ್ ಯು ಆರ್ ಆಲ್ ಯುನಿಕ್.
Every lawyer is unique. The way I argue a case is different from the way somebody else argues a case. Now, am I better than that person? No. Each one has their own way of making a presentation in court. Each one is good. It all depends upon how involved you are in making your position in court clear. Now, there is a very subtle distinction. That is another challenge in this profession. These are all unique to this profession. You are not, it's not like a doctor's profession. I mean, doctor doesn't get involved in the surgery that he does. But in this profession, you can get involved in the litigation of somebody else. In that process, you are going to hurt the institution, namely the institution of the court system itself. That is why we are supposed to be one step away from the client's involvement. Therefore, they say don't get involved emotionally with the clients. Why? Because if you get emotionally involved, you are likely to make a wrong presentation in the court, which could be unethical. If you do that wrong presentation in court, it is going to bring down the institution itself. If the institution comes down, the country comes down. Democracy is gone. Because judiciary is not part of democracy. Judiciary is democracy.
Correct.
So therefore, look at the responsibility that you have as a lawyer. And if you ask me, enumerate 1, 2, 3, 4 qualities to be a good lawyer, it is difficult. You can enumerate 10, there is still 11th. But basic thing is what I just now mentioned: hard work, love your profession, be knowledgeable, and all this you have to do it in an ethical manner.
An advocate is expected to know everything.
An advocate is expected to know everything. He is supposed to be good in law. He is to be good in the law of righteousness or dharma. He should know literature, whether it is Kannada, whether it is English, whether it is Sanskrit, whether it is any other language. You are in a learned profession. Learned need not necessarily mean learned in the law.
Learned.
You are learned.
learned friend.
It doesn't require too much of a talent to read CPC, Evidence Act, ivaga BNSO, BNSSO, all this doesn't require great, it's not rocket science. A person with average intelligence can do it. But there is something more that makes a difference between an eminent lawyer and a not an eminent lawyer. What is the difference? It is the overall knowledge of world and worldly matters, which includes literature, which includes philosophy, which includes languages, everything. You don't have to be an expert, but you must know what is happening.
So more than anything, common sense is required.
Common sense is required, general knowledge is very important. You have to know history, you have to know geography, you have to know a little bit of science.
ಸೊ ಈಗ ಪ್ರೊಫೆಷ್ನಲ್ ಎಥಿಕ್ಸ್ ಮಾತಾಡೋದು ಬಂದರೆ, ಈಗ ನಾವು ಅಡ್ವೊಕೇಟ್ಸು ಒಂದು ಸೈಜ್ ಬೋರ್ಡ್ಗಿಂತ ದೊಡ್ಡದು ಹಾಕಬಾರ್ದು, ಅಡ್ವರ್ಟೈಸ್ ಮಾಡಬಾರ್ದು ಅಂತೆಲ್ಲ ಇದೆ. ಬಟ್ ಟುಡೇ ವಿ ಆರ್ ಇನ್ ಏರಿಯಾ ಆಫ್ ದ ಎರಾ ಆಫ್ ಸೋಷಿಯಲ್ ಮೀಡಿಯಾ. ಇಲ್ಲಿ ಎಲ್ಲವೂ ಸೋಷಿಯಲ್ ಮೀಡಿಯಾಕ್ಕೆ ಅವೈಲೇಬಲ್ ಇದೆ. ಈಗ ಒಬ್ಬ ಅಡ್ವೊಕೇಟ್ ಬಗ್ಗೆ ಗೂಗಲ್ ಪೇಜಸ್ ಇರ್ತವೆ, ವೆಬ್ಸೈಟ್ಸ್ಗಳೇ ಇರ್ತವೆ. ಅದು ಎಷ್ಟು ಸರಿ ಸರ್ ಅಥವಾ ತಪ್ಪು?
ನೋಡಿ ಮಿಸ್ಟರ್ ಹೆಗ್ಡೆ, ವಿ ಹ್ಯಾವ್ ಟು ಬಿ ಅಗೇನ್ ಪ್ರಾಕ್ಟಿಕಲ್ ಅಬೌಟ್ ಇಟ್. Now what was the situation 25 years ago is not the situation today. Today the world has become flat. Legal practice is not confined to one particular geographical area. It is all across the world. Now board must be of a particular size. I mean, what does it matter which size the board is? What is prohibited? Prohibiting is canvassing. Now there is a difference between canvassing for work and telling somebody, look, I am proficient in the following branches of law. Look at the legal profession, how it has grown. There was a time maybe 25 years ago or 30 years ago that specialization was something totally foreign to the legal profession. Everybody would do everything. Unlike medical profession, where you have doctors specialized in certain specific areas of medicine.
Organs of the body.
Organ of the body. That was not there in the legal profession, but today it is a good sign that it is coming. There are people who are proficient in intellectual property, there are people who are proficient in direct taxes, indirect taxes, constitutional law, commercial law, international law, criminal law, they are all different. There are people who are specialized in foreign trade law, there are people who are specializing in sports law, there are people who are specializing in space law,
environmental law.
Now, how does a person sitting 10,000 miles away know who is proficient in a particular subject in Bangalore or Delhi or Bombay, wherever?
LA.
That requires you to tell them, look, I am practicing in this field of law. If you come to a lawyer who is proficient in cinema law with a matrimonial matter, I mean, it's not correct. It is not good for the client, it is not good for the lawyer also, and it is not good for the growth of the profession as a specialized body of knowledge. Therefore, answer to your question, should there be this type of social media advertisement? Canvassing, don't canvass.
Not canvass.
But if you say, well, so and so is good in the following branches of law, he is a good litigating lawyer, he is a good non-litigating lawyer, a good corporate lawyer.
Your profile is available. Your profile available on media. It is not wrong.
Not wrong at all, according to me. That is not to be prohibited. In fact, that is to be encouraged so that people know in what branch of law you are good. It will lead to specialization. That is my view on this subject.
Sir, now ಈ ಡೆಸಿಗ್ನೇಟೆಡ್ ಅಡ್ವೊಕೇಟ್ಗೂ ಡೆಸಿಗ್ನೇಷನ್ಗೂ ಏನು ವ್ಯತ್ಯಾಸ ಸರ್?
ನೋಡಿ, this designation has quite been unfortunately in this country, it has been a journey which is not very savory. First, what is this distinction that we have created between advocates and senior advocates? We have created a caste system amongst lawyers. According to me, therefore, that provision in the Advocates Act providing for designation and senior advocates and advocates should be declared unconstitutional according to me. In fact, Supreme Court according to me missed a golden opportunity of saying all this distinction is irrelevant in the practice of the legal profession. Legal profession, who determines? Ultimately the choice of the lawyer, it is the client. Who determines whether you want the services of a senior person for the purpose of the case? It is the joint decision of the client and the lawyer. Advocate. They may come and say, well, we want somebody who is experienced to come and make a submission in court. Leave it to them. And I do not understand how courts, whether the Supreme Court or the High Court, can come into the scene for designating a person as a senior advocate. What is the role of a court? The role of a court is simply justice dispensation. Decide cases where there are dispute, and at the most you are in charge of administrative control of the subordinate judiciary. Administrative control, not judicial control. When it comes on the judicial side, you do what you want on the appellate side or on your judicial review side. But you do not control the exercise of a function of a judge. You look at the order. That is a different matter. Therefore, what is the role of a court in interfering with who should be a senior advocate, who should not be a senior advocate? So, therefore, according to me, this entire institution is something which is foreign to our culture. We should simply, this is again part of the British legacy. ಇದನ್ನು ಆದಷ್ಟು ಬೇಗ ಇದನ್ನು ನಾವು ಕ್ಲೋಸ್ ಮಾಡಿ, and now we have made a mess of it. Application no, prove yourself. I will tell you one thing. Now look at this points that are given. ಈಗ reported judgments, some 10 points or 15 points ಏನೋ ಹಾಕಿದ್ದಾರೆ. Now you are assuming that all of them are practicing in the High Court. Why should it be that way?
Correct.
In the subordinate judiciary, don't you have good lawyers? Reported ಇಲ್ಲ ಅವರಿಗೆ.
Opportunity ಇಲ್ಲ
because you don't report the judgments of the subordinate courts. So therefore, the whole thing is, according to me, completely messed up.
ಆಮೇಲೆ ತಾವು ಹೇಳ್ದಂಗೆ ಈಗ ವಕೀಲರಲ್ಲಿ ಜಾತಿಗಳು ಬೇಕಾಗಿಲ್ಲ. ಯಾವ ಜಾತಿ ನಿಮ್ಮದು? ನಿಮ್ದು ಯಾವ
ಸೀನಿಯರ್
ವಿಚ್ ಕ್ಯಾಸ್ಟ್?
ಅನ್ನೆಸೆಸರಿ.
ವಾಟ್ ಐ ಮೀನ್ ಟು ಸೇ ಇಸ್ ವಕೀಲರದ್ದು ಒಂದು ಜಾತಿ
ಅಷ್ಟೇ. ಅದರಲ್ಲಿ ನೀವು ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್, ನೀವು ಜೂನಿಯರ್ ಆರ್ಡಿನರಿ ಅಡ್ವೊಕೇಟ್, ಇದೆಲ್ಲ ಯಾಕೆ ಬೇಕು?
ಶಿಕ್ಷಿತರು, ಅಶಿಕ್ಷಿತರು ಅಷ್ಟೇ, ಶಿಕ್ಷಿತರು ಅಷ್ಟು ಸಾಕು. ಸೊ ಆ ಜಾತೀಯತೆಯನ್ನು ಮೀರೋದಕ್ಕೋಸ್ಕರ ಸಮಾಜ ಕೂಡ ನಮ್ಮನ್ನು ನೋಡ್ತಾ ಇರುತ್ತೆ ಅನ್ನೋದಕ್ಕೆ.
Exactly. And you know, there is another thing that has happened. When senior lawyers appear, the treatment that is given in court is different. That is the perception. Why all that? Why did you create this? The law has created a ghost. We should now scrap it as early as possible. That is my view.
ಸೊ ಈಗ ತಾವು ದೇಶದ ಎಲ್ಲ ಕೋರ್ಟ್ಗಳಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಿ, ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತಾ ಇರ್ತೀರಿ. ಸೊ ಏನು ಡಿಫ್ರೆನ್ಸ್ ಸರ್ ಹೈಕೋರ್ಟಲ್ಲಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡೋದಕ್ಕೂ, ಲೋವರ್ ಕೋರ್ಟ್ಸಲ್ಲಿ ಇರೋದಕ್ಕೂ, ಸುಪ್ರೀಂ ಕೋರ್ಟಲ್ಲಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡೋದಕ್ಕೂ? ವಾಟ್ ಈಸ್ ದ ಡಿಫ್ರೆನ್ಸ್ ಸರ್?
The difference is quite obvious. You see, in the lower court, you should do trial work. Everything is open. The canvas is available. The different colors of the paint are available. You are the artist. You can create the picture you want. So there is a lot of creative work that goes on when you are a trial lawyer. But High Court ಗೆ ಬಂದಾಗ ಅಷ್ಟು ಕ್ರಿಯೇಟಿವಿಟಿ ಇಲ್ಲ. See, you have to work within the restrictions of the jurisdiction of a appellate court or the on the writ side. You don't create new evidence. You can create evidence. You can do so many things in the lower courts. You can put in a lot of your different types of evidence which will not be available in high court in the lower court. And therefore, the style of approach to a litigation in the trial court is different from the approach in the high court. Now when you go to Supreme Court, naturally it is very different because you are focusing only on a question of law. Now approach is completely different. If you are a good trial lawyer, you can reasonably expect to be a good appellate lawyer. If you are only an appellate lawyer, you will not be a good trial lawyer.
ಟ್ರಯಲ್ ಲಾಯರ್ ಸರ್, ಇವತ್ತು ದೇಶದಲ್ಲಿ ತುಂಬ ವ್ಯಾಜ್ಯಗಳು, ದೇರ್ ಆರ್ ಪೆಂಡೆನ್ಸಿ ಆಫ್ ಕೇಸಸ್ ಇಸ್ ಡೇ ಬೈ ಡೇ ಇಟ್ಸ್ ಇನ್ಕ್ರೀಸಿಂಗ್, ನಾಟ್ ಡಿಕ್ರೀಸಿಂಗ್. ಸೊ ಈ ಪೆಂಡೆನ್ಸಿ ಆಫ್ ಕೇಸಸ್ಸು ಮತ್ತು ತ್ವರಿತ ನ್ಯಾಯದಾನ ಅದು ಮಾಡೋದಕ್ಕೆ ಏನು ಮಾಡಬೇಕು ಸರ್?
ನಿಮ್ಮ ಪ್ರಶ್ನೆಗೆ ಎರಡು ಅಪ್ರೋಚ್. ಇಷ್ಟೊಂದು ವ್ಯಾಜ್ಯಗಳು ಜಾಸ್ತಿ ಆಗಿದೆ, ಇಸ್ ಇಟ್ ಎ ಗುಡ್ ಸೈನ್ ಆರ್ ಎ ಬ್ಯಾಡ್ ಸೈನ್? ಇಟ್ಸ್ ಎ ಗುಡ್ ಸೈನ್.
Increasing in number of cases, it's
a good sign.
But the pendency.
We will come to that. Therefore, first, should we reduce the number of cases? No, you don't do all that. If people want to exercise their right and they want to come to court, ಅಂದರೆ ಏನು ಮೀನಿಂಗು? ನಮಗೆ ಕೋರ್ಟಲ್ಲಿ ನಂಬಿಕೆ ಇದೆ, ನಾವು ಬೀದಿಲಿ ನಮ್ಮ ವ್ಯಾಜ್ಯನ ಪರಿಹರಿಸಿಕೊಳ್ಳೋದಿಲ್ಲ. ದಟ್ ಈಸ್ ದಿ ಹಾಲ್ಮಾರ್ಕ್ of a progressing civilized society. That is point number one. ವ್ಯಾಜ್ಯಗಳು ಜಾಸ್ತಿ ಆಗ್ತಾ ಇದೆ, therefore how do we tackle it? Tackle it, one, by improving the infrastructure. In place of one court, you must have 10 courts. In place of one judge, you must have 10 judges. You must have laws which will prevent unnecessary delay. By experience we have understood how delays take place, and let me speak about it from the point of view of a lawyer. ನಾವು ವಕೀಲರು ಈ ಪೆಂಡೆನ್ಸಿನ ಕಡಿಮೆ ಮಾಡೋದಕ್ಕೆ we can play a major role. How do we play that role? First, ನಾವು ಕಕ್ಷಿಗಾರ ನಮ್ಮ ಹತ್ರ ಬಂದಾಗ ಈ ಕೇಸಲ್ಲಿ ನಿನಗೆ ಏನಾದರೂ ಹುರುಳಿದೆಯಾ, ಇದು ಯೂಸ್ಲೆಸ್ ಕೇಸ ಅಂತ ನಾವು ಫ್ರ್ಯಾಂಕ್ ಆಗಿ ಆನೆಸ್ಟ್ ಆಗಿ ಅಡ್ವೈಸ್ ಮಾಡಬೇಕು. ಬಂದಿದ್ದೆಲ್ಲ ನಾವು ಕೋರ್ಟ್ಗೆ ಹಾಕ್ತೀನಿ ಅನ್ನೋದು ತಪ್ಪು. ಹಾಗೆ ಮಾಡಿದ್ರೆ ನಾವೇನೇ ಫಿಲ್ಟ್ರ್ ಮಾಡೋ ಥರ ಆಗುತ್ತೆ. ದಟ್ ಈಸ್ ಅವರ್ ಜಾಬ್. ಕ್ಲೈಂಟ್ ಕೇಳ್ತಾನೋ ಕೇಳೋದಿಲ್ವೋ ಅದು ಬೇರೆ ವಿಷಯ, ದಟ್ ಈಸ್ ಹಿಸ್ ರೈಟ್. ಈ ಕೆಲಸ ಇಲ್ಲ ಸರ್, ನೀವು ಹೇಳ್ಬೋದು, ಆದರೂ ನಾನು ಹಾಕಲೇಬೇಕು, ನೀವು ಮಾಡಿದ್ರೆ ದಟ್ಸ್ ಆಫ್ ಕೋರ್ಸ್, ದಟ್ ಇಸ್ ಹಿಸ್ ಚಾಯ್ಸ್. ಬಟ್ ನಿಮ್ಮ ಡ್ಯೂಟಿ ಏನು? ಇಲ್ಲಪ್ಪ ಈ ಕೇಸ್ ನಿನಗೆ ಪ್ರಯೋಜನ ಇಲ್ಲ, ನಿನಗೆ ಏನೂ ಇಲ್ಲ, ಇದು ಲಿಮಿಟೇಷನ್ ಬಾರಾಗಿದೆ, ಅಥವಾ ಈ ಕಾನೂನಲ್ಲಿ ನಿನಗೆ ಹಕ್ಕಿಲ್ಲ, ಅದನ್ನು ಹೇಳೋದು ನಮ್ಮ ಕರ್ತವ್ಯ. ಅದನ್ನು ಮಾಡಿದ್ರೆ ಯು ವಿಲ್ ರಿಡ್ಯೂಸ್ ಪೆಂಡೆನ್ಸಿ. ಪಾಯಿಂಟ್ ನಂಬರ್ ಎಟ್ ದ ಫಸ್ಟ್ ಸ್ಟೇಜ್ ಇಟ್ ಸೆಲ್ಫ್ ಯು ವಿಲ್ ರಿಡ್ಯೂಸ್. ಸೆಕೆಂಡ್, ವೆನ್ ದ ಮ್ಯಾಟರ್ ಕಮ್ಸ್ ಟು ಕೋರ್ಟ್, ದಿಸ್ ಕ್ರೇಜ್ ಆಫ್ ಟೇಕಿಂಗ್ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ must stop. What can judges do if lawyers don't cooperate? Nothing. Okay, at a particular point of time, judges can say, no, I am refusing it, please argue it. Once, twice, thrice, ಎಲ್ಲ ಬರೀ ಜಡ್ಜ್ಗಳಿಗೂ ಲಾಯರ್ಗಳು ನಿಷ್ಠುರ ಕಟ್ಕೊಳಕ್ಕಾಗತ್ತಾ? You can't do that. Therefore, we have to ensure that we lawyers do not ask for adjournment unnecessarily. You see, look at it from the point of view of, this is a larger picture of speedy justice. Take it from a myopic point of view. Delay is not good for you as a lawyer. ಈ ಒಂದೇ ಕೇಸ್ಗೆ ಎಷ್ಟು ಸಲ ಅಂತ ಹೋಗ್ತೀರಿ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೊಂಡು, ಅದೇ ಕೇಸ್ನ ಎಷ್ಟು ಸಲ ಅಂತ ಓದ್ತೀರಿ? ಇಸ್ ಇಟ್ ನಾಟ್ ಎ ವೇಸ್ಟ್ ಆಫ್ ಟೈಮ್ ಫಾರ್ ಅಸ್? ಈ ಕೇಸ್ ಮಾಡ್ಬೋದು, ಬೇರೆ ಕೇಸ್ ಮಾಡ್ಬೋದಲ್ಲ, ಒಂದೇ ಕೇಸ್ ಮಾಡ್ಕೊಂಡು. ವಿ ಶುಡ್ ನಾಟ್ ಡೂ ಇಟ್ unless there is something so important. See, look at the unfortunate situation sometimes I have seen. ಫಸ್ಟ್ ಅಪೀಲ್ ಹಾಕಿದ್ದಾರೆ. ಒನ್ ಆಫ್ ದ ಗ್ರೌಂಡ್ ರೇಸ್ಡ್ ಈಸ್ ದಿ ಆರ್ಡರ್ ಆಫ್ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಈಸ್ ಎರೋನಿಯಸ್ ಬಿಕಾಸ್ ದಿ ಆರ್ಡರ್ ಹ್ಯಾಸ್ ನಾಟ್, ಜಡ್ಜ್ಮೆಂಟ್ ಆ್ಯಂಡ್ ಡಿಕ್ರಿ ಹ್ಯಾಸ್ ನಾಟ್ ಕನ್ಸಿಡರ್ಡ್ ಎಕ್ಸಿಬಿಟ್ P5. ವೆರಿ ಗುಡ್. ಹೈಕೋರ್ಟಲ್ಲಿ ಬಂದು ಜಡ್ಜು ಎಕ್ಸಿಬಿಟ್ P5 ಏನ್ರಿ ಅಂದರೆ ನನ್ನ ಹತ್ರ ಕಾಪಿ ಇಲ್ಲ ಅಂತ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತೊಗೊಂಡ್ರೆ ಇದು ಯಾವ ಧರ್ಮ ಇದು? ದಿಸ್ ಇಸ್ ದ ಪೊಸಿಷನ್. So therefore it is very important for us as lawyers not to ask for adjournment unnecessarily. You have to be very reluctant. Adjournment must be an exception, not a rule. Unfortunately today adjournment has become the rule, going on with the case has become exception. ಈ ಥರ ಇದ್ದರೆ ನೀವು ಎಷ್ಟೇ ಜಡ್ಜ್ಗಳನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡಿ, ನೀವೆಂಥ ಕೋರ್ಟೇ ಮಾಡಿ, ನೀವೇನೇ ಕಾನೂನು ಮಾಡಿ, ನೀವು ಈ ಪೆಂಡೆನ್ಸಿನ ಪರಿಹಾರ ಕಡಿಮೆ ಮಾಡೋಕ್ಕಾಗೋದಿಲ್ಲ. Therefore, speaking from the point of view of the role of a lawyer, we have a major role to play in reducing the workload in the court. Look at the amount of time that is spent with one adjournment. Lawyer time waste, judge time waste. ಆ ರೆಕಾರ್ಡು ವಾಪಸ್ಸು ಸೆಕ್ಷನ್ಗೆ ಹೋಗಿ, ಸೆಕ್ಷನ್ನಿಂದ ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ಗೆ ಹೋಗಿ, ಬೋರ್ಡ್ ಬ್ರಾಂಚಿಂದ ತಿರ್ಗಾ ಲಿಸ್ಟ್ ಆಗಿ, ಹೌ ಮಚ್ ಆಫ್ ಮ್ಯಾನ್ ಅವರ್ಸ್ ಆರ್ ವೇಸ್ಟೆಡ್. And if you calculate the cost for each, nothing comes free. A clerk who has to do the same listing over and over again spends time. You pay that clerk, it costs money. The judge has spent half an hour on the case when it is adjourned. The judge is paid his salary. How much are you going to waste on all this? This is what we have to be conscious about. So my appeal to all our, especially our younger generation is, let us not waste our time asking for adjournment. It is a waste of time for everyone.